Hello everyone, this is the video of Legal Studies, Class 12, Unit 2nd, namely Topics of Law, and the last topic of Unit 2 is Administrative Law. This topic is very much important like all previous topics. Okay, as in everyday's life, we come across this. Though we do not notice this, but it is there that directly indirectly we are related to this. So we have to understand this law in order to exercise own rights, powers, duties, everything. Okay, so this law will make you understand what all these administrative bodies around which you are living are and what are their duties, responsibilities and the powers. Okay, so if you understand that, then you can avail your right, or better to say rights, adequately. Okay, and how it will happen? Let's understand first the meaning of administrative law, and then you will automatically understand what I am trying to explain through this topic. Okay, so let's begin with the question of what is administrative law. What is meaning of administrative law? Administrative law is a branch of public law. So it is not a personal law. The first thing that keep in mind, it is a public law that governs the activities of administrative agencies of government. So see, government has different departments like revenue department, the railway department, income tax department, sales tax department. Okay, there are dozens of such departments. Okay, so all those departments have their own rules and regulations, and there are administrative laws that governs their functionality, right? Okay, so it's not like that they can work or they can exercise their powers suo motu or arbitrary, not at all. Everything is well defined under this administrative law. Okay, so the activities and actions of such government agencies are rule making, adjudication, or the enforcement of a specific regulatory agenda. Okay, so whatever the thing, see, if something wrong you did, maybe if you are allowed to make the 3 stories building and you made 4 stories, simply what will happen? The respective authority department will come and demolish your one floor. Okay, so that is the thing happen. So that is the thing possibly will happen, right? So all these things being conducted by these administrative bodies, and they have well power to do that. Okay, so this is one of the aspects, but there are different aspects as well as that we will discuss while discussing this topic in detail. So but you need to understand that, so everything need to be happen in the given framework. Okay, and that is defined by the law. Furthermore, the administrative law deals with the decision making of such administrative units of government such as tribunals, boards, commissions that are part of a national regulatory scheme in such areas as police law, domestic administration, taxation, internal trade, manufacturing, the environment, broadcasting, immigration and transport. So you can see how many departments are there. So every department has its own role, its own power, its own function in given area. Okay, and they can make decision regarding that. Okay, that is their powers. So in short, we can say that administrative law describes the powers of administrative authorities. Powers here include the functionality of these authorities, the responsibilities of these authorities, the duties of these authorities. Okay, and then fixes the limits of the powers of all such administrative authorities. What does it mean that? First, what we have discussed, that administrative law describes the powers of administrative authorities. So, powers means, it doesn't mean that it has the unlimited, unfettered power. No, it is limited. So, how you come to know that? So, the second sentence answers that. What administrative law does, it fixes the limits of the powers of all such administrative authorities. So, in the first instance, it has given the power. In the second instance, it is limiting its powers. Okay? And in the third instance, prescribes the procedure to be followed in exercising such powers by all such administrative authorities. What does it mean that? So, of course, they have been given the limited power. Okay, from the first two sentences we can infer that. But in the third sentence, it is saying that it is not like that. Though they have the limited power, it doesn't mean they can exercise that in their own ways. No, even the procedures are prescribed to exercise those powers. And finally, gives the means to control these administrative authorities through judicial and other such means. So, however, in all the cases, if it is so well defined, if something wrong happen, then of course judiciary is there to control the things, to review the things, and then accordingly decides the thing. Right? So that is the meaning of administrative law. Now the next question is, what is the purpose of administrative law? Well, of course, if there is something, then that must be having some purpose, isn't it? So, administrative law has also very meaningful purposes. Okay? Prima facie, the first purpose of administrative law is to define the roles and responsibilities of the administrative authorities. Okay? However, at the same time, it also checks and balances the administrative power in case if someone tries to exceed or misuse his or her administrative power. Furthermore, it also protects the common man if any administrative power tries to encroach his rights without any reasonable reason. Okay? So, you need to understand this administrative law, because through this you can protect your interests and rights. Okay? And lastly, it makes every administrative officer and other such employee who exercises public power accountable to the people. Okay? So these four are the major purposes of administrative law. Now the next question is, what are the sources of administrative law? Well, there is as such no defined, codified, well-written, a single book of administrative law, as we have the Indian Penal Code, Criminal Procedure Code, Civil Procedure Code, isn't it? So we don't have any defined and written administrative law. Instead, it is in fact unwritten law, or you can say it customary law, which is in practice, right? However, the major sources of administrative law that we can easily trace in some other legislation are constitutional law, that is the major source and main source of administrative law, the fundamental rights, the provision of judicial review, the provision of administrative tribunals, etc. are the parts of administrative law. Right. The second source of administrative law is case laws. Okay. As we have discussed that it is customary. So it is of course being taken from the decided cases. And the third one is the comments of judges. So these three are the major sources of administrative law. Now the next question that we have, that is, what is the scope of administrative law? So in order to get the answer of this question, first you need to understand what is meaning of a scope in this context, right? So the meaning of a scope in this question is the areas that administrative law covers. So it is talking about the areas that administrative law covers. So check out the major coverage areas of administrative law under the heading of scope of administrative law. Existence of various administrative agencies. Okay, for example, Commission of Inquiry and Advisory Boards, Central Board of Revenue, Tariff Commission, etc. Okay. The second one is rule making power of administrative agencies. For example, delegated legislation, safeguard against abuse of power and judicial control. The third one is judicial functions of administrative agencies like administrative tribunals, for example, industrial tribunals, income tax appellate tribunal, etc. Next one is remedies, for examples, mandamus, certiorari, prohibition, injunction, used to prevent excess use or abuse of power. You know that this is directly talking about the Article 32 and 226 of the Indian Constitution, and what these two articles discuss, you know it, isn't it? The next one is procedural guarantees. It means the rules that ensures natural justice. And the next one is public corporation. It means public corporations' liability and responsibilities towards public. And the last one is government liability. It means under the tort law, the union and state government will be liable in case if any government official commits mistake or misuse the power. Likewise, these 7 are the major scopes of administrative law. Now, the next question that we have, that is, what were the reasons of growth of administrative law? Well, of course, this is interesting question. So, what was the concept or idea behind developing this administrative law? There are following points that will answer this question. The first point is to ensure the welfare state, because the purpose of administrative law, by the time I believe you must understood the meaning and concept of administrative law. So see what it does in a democratic society. It ensures the welfare state, means it protects the interest of every person, isn't it? And maintains the equality in the society. Secondly, it harmonizes the day-to-day affairs of people through rules and regulations. Okay, and lastly, depending upon the demand of the situation, administrative actions need to be taken to ensure the peace and security in the society. So these were the reasons of growth of administrative law. So this is all for this video. So what are the things that we have discussed in this video? The first one, that is meaning of administrative law. Secondly, we have discussed the purpose of administrative law. Thirdly, we have discussed what is the scope of administrative law. And lastly, we have discussed the reasons of the growth of administrative law. Okay, in my next video, I will be discussing about the major differences between constitutional law and administrative law. So keep watching.